Okay, let's unpack this. Picture yourself in court for a moment. A really critical fact needs proving.
Hmm.
But the only evidence you have is something someone said, you know, outside the courtroom, not under oath.
And crucially, where the person facing trial can't challenge them directly.
Exactly. Think about that someone's freedom, their liberty, potentially resting on words spoken, well, anywhere but in the controlled environment of a trial. Can that really be fair?
It raises some really fundamental questions, doesn't it, about reliability, credibility, the ability to actually test evidence.
Right.
And those questions, they're right at the heart of one of the most, well, long-standing and, let's be honest, complex rules in the law of evidence, the rule against hearsay.
And today, that's exactly what we're doing, a deep dive into the rule against hearsay, specifically looking at how it works in criminal proceedings now under the Criminal Justice Act 2003. We're going to explore sort of the challenges this rule throws up, how the law has grappled with them over time, and, where we actually stand now.
Yeah, and this deep dive, it's specifically designed for educational purposes. It's built on materials made available by the brilliant University of London.
We should definitely say we're incredibly grateful to the University of London for making these resources accessible. They're invaluable.
Absolutely. Our aim here is really to help you navigate this, well, often tricky area of law, especially if you're maybe gearing up for exams.
Yes, definitely. We know hearsay is one of those topics that can feel, well, a bit overwhelming. So our mission today is to break it down, highlight the really essential concepts, the key cases, we'll repeat those case names, and the statutory provisions.
And yeah, we'll be reinforcing those key details as we go, hopefully to help with memorization.
Think of this as getting you ready, getting you confident to tackle those problem questions and essays on hearsay.
And we're really delighted that this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Yeah, fantastic. And to everyone using this as part of your studies, maybe you've got exams looming seriously, the very best of luck from both of us.
Good luck.
So what's our journey looking like today? We're going to kick off with the bedrock, the classic common law definition, and frankly, the problems it created.
Then we'll trace how the Criminal Justice Act, 2003, the CJA, really reshaped the whole landscape. We need to define exactly what hearsay is under the Act using that crucial purpose test.
Ah, yes, and the twist framework will definitely unpack
Ugh,
twist.
we absolutely will. From there, we'll explore the different gateways the exceptions Parliament built into the Act. These are the rules that allow hearsay in, but only under specific circumstances.
Like unavailability of the witness?
Exactly. Unavailability under Section 116. We'll also look at preserved common law rules, like res geste under Section 118, and the flexible but carefully controlled interests of justice exception in Section 114 1D.
Okay, and it's not just about getting the evidence in, is it? There are safeguards too.
Vitally important. We'll look at the supplementary safeguards the Act provides to try and reduce the risks of admitting hearsay. Things like provisions for challenging the credibility of the absent witness, or even stopping the trial altogether in some cases.
And the big one, human rights.
Crucially, yes. We have to grapple with the impact of human rights law, specifically Article 6 3D of the European Convention, the right to confront witnesses. We'll look at how the UK courts and the European Court of Human Rights in Strasbourg have, well, debated this,
Quite intensely at times.
indeed, and how they ultimately found a way for the CJA 2003 framework to operate compatibly with that right.
Right. And finally, we'll just touch on the ever-present role of relevance and then wrap up with some critical evaluation points, things for you to think about, and maybe some pointers on applying all this in exam scenarios.
It's a fair bit to cover, but it's absolutely essential for understanding criminal evidence today.
Okay, let's start at the beginning then. The common law.
Right. At common law, the rule against hearsay was famously strict. The classic definition, you often see it attributed to Cross, basically stated that a statement other than one made by a person while giving oral evidence in the proceedings is inadmissible as evidence of any facts stated.
Okay, that sounds pretty absolute. Inadmissible as evidence of any fact stated.
It was. So if you wanted to prove, say, that the defendant was at the scene of the crime,
Yep.
you couldn't just call a witness, W, to say, oh, I heard Z say the defendant was there.
No, you'd have to call Z the person who actually saw him.
Exactly. Z has to come to court, give evidence under oath, and face cross-examination.
And the reasons for that strictness were rooted in fairness and reliability, weren't they?
Absolutely. Think about it. An out-of-court statement wasn't made under oath, The maker wasn't formally swearing to tell the truth.
And you couldn't cross-examine them. You couldn't probe their memory, their perception, ask if they were biased or had a reason to lie.
Precisely. The jury couldn't see their demeanor either, how they behaved while saying it, to help judge if they were telling the truth. There seemed to be a real danger of mistakes, misreporting, even deliberate lies creeping into the trial process unchecked.
So the rule was essentially a protective shield, designed to keep potentially unreliable, untested stuff out.
That was the idea. But over time, this very strict common law rule, even though it developed lots and lots of exceptions, often quite complicated ones.
It became incredibly rigid, didn't it? And, well, a bit of a mess.
It really did. It became, in the famous words of Lord Reed in the case of Myers v. DPP back in 1965, absurdly technical.
Absurdly technical.
And that rigidity, that technicality, it could actually lead to miscarriages of justice.
Yeah.
Sometimes it stopped defendants from using evidence that might have helped them. There's the case of Sparks from 1964, often cited as an example where a child victim's statement identifying her attacker was excluded, potentially unfairly.
So it highlights that tension, doesn't it? Balancing the need for reliable, tested evidence against, well, the need to actually hear relevant evidence, especially if strict rules might lead to an unjust outcome.
That's the perpetual balancing act in evidence law. And that tension is really what drove the reforms. Civil proceedings saw the rule pretty much abolished by the Civil Evidence Act in 1995.
But criminal law needed a more nuanced approach.
Exactly. And that came with the Criminal Justice Act 2003. The CJA 2003 codified the general rule against hearsay. You find it in Section 114, subsection 1. It still says a statement not made in oral evidence is inadmissible if it's used as evidence of any matter stated.
Okay, so the general rule remains. What changed?
The key changes were narrowing the scope of what counts as hearsay in the first place, and critically, expanding and clarifying the exceptions, the gateways for admissibility. It also preserved a few key common law exceptions via Section 118.
So the aim was a more flexible system, less technical than the common law, hopefully better at balancing relevance and fairness.
That was the goal, to move away from the absurdly technical position.
Okay, so the CJA maintains the general exclusionary rule, but it changes how we define what falls within that rule and gives clearer routes for exceptions. Let's focus on that definition first. This seems absolutely fundamental for any problem question.
It is. The bedrock principle hasn't changed. The rule against hearsay excludes an out-of-court statement only when it's being used to prove the truth of the matter stated within it.
Right, the rule of use. It all depends on why you're trying to introduce the statement.
Exactly. And this is where that crucial distinction between hearsay and what we call original evidence comes in. You need to get your head around this.
Original evidence, that's where the statement is admissible just because the fact that it was made is relevant, isn't it? Whether it's true or not doesn't matter for that purpose.
Perfect. The statement's very existence, the fact it was uttered, is the point, not its accuracy.
Let's use that simple example again. The issue is whether X speaks English. Witness W says, I heard X say, I went to London yesterday.
Okay. If you're using W's testimony to prove X speaks English, the fact X uttered those English words is relevant. Whether he actually went to London is irrelevant for that specific purpose. So W's evidence about what X said is original evidence.
But if the issue in the case is whether X was actually in London yesterday.
Now if you offer W's testimony of X saying, I went to London yesterday to prove X's location.
Then you are using it to prove the truth of what X stated, and that makes it hearsay.
Precisely. Same statement, different purpose, different classification.
And the case that really nailed this distinction at common law, the one we absolutely must remember.
Subramaniam v. Public Prosecutor. It's a Privy Council case from 1956.
Subramania. Got it.
Subramaniam was charged with possessing ammunition during the Malayan emergency. His defense was duress. He claimed terrorists had threatened him.
Okay.
He wanted to tell the court what the terrorists had said to him, the threats they made. The trial judge refused, saying it was hearsay.
But the Privy Council disagreed.
They did. They allowed his appeal. Why? Because Subramaniam wasn't trying to use the terrorists' statements to prove the truth of the threats, like that they genuinely would have killed him if he didn't comply.
Ah, I see. He was using them to prove that the threats were made.
Exactly. The fact that the threats were made was directly relevant to his state of mind and therefore to his defense of duress. It didn't matter if the terrorists were bluffing. The fact they said it was the crucial point.
So the statements were admissible as original evidence because their relevance came from the fact they were uttered, not the truth of what was asserted.
That's the essence of it. Subramaniam v. Public Prosecutor, 1956. A cornerstone case for understanding the rule of use.
Okay, purpose is everything. Now, the CJA 2003 codified the rule, and you said it includes a specific definition of matter stated. And this tackled a tricky common law area, implied assertions.
Yes, Section 115, subsection 3, shillin 115 3, defines matter stated. It says a matter stated is one where a purpose note, just a purpose, not the only one of the person making the statement, was either A, to cause another person to believe that matter,
Okay.
or B, to cause another person to act or even a machine to operate on the basis that the matter stated is true.
Right. This definition, this was Parliament's way of dealing with cases like Cairley, wasn't it? From 1992.
That's exactly right. Remember, in Kearley, the police answered the defendant's phone, and lots of callers asked for drugs. The House of Lords said this evidence was inadmissible hearsay because the calls implicitly asserted that the defendant was a drug dealer.
And implied assertions were a real headache under the common law, weren't they? Very confusing.
They were notoriously difficult. But S1153 brings clarity by forcing us to ask, what was the maker's purpose? Think about the people calling Kearley. What was their purpose?
Well, they wanted to buy drugs.
Right. Was their purpose to cause Kearley to believe he was a drug dealer?
But presumably he already knew if he was or wasn't.
Was their purpose to cause him to act on the basis that he was a dealer? Well, yes, in the sense they wanted him to supply drugs. But the act focuses on causing belief in the matter stated or action on the basis the matter is stated. Their primary purpose was the transaction, not communicating the assertion, you are a dealer.
So because the caller's purpose wasn't primarily to make Curley believe the implied assertion that he was a dealer or act on that specific belief under S1153, those calls are not hearsay evidence that he was dealing.
Correct. They are not hearsay for that purpose under the CJA definition. They might still be relevant as original evidence. The fact that numerous people called that number asking for drugs is certainly circumstantial evidence relevant to drug supply at that location. But the calls themselves aren't treated as hearsay assertions of his status as a dealer. It's a major shift from Kearley.
Okay, that's a crucial change. S1153 focuses squarely on the maker's intention regarding the specific matter stated. But applying this, especially to implied assertions, still sounds potentially tricky.
It can be, which is why the courts developed an authoritative test. You absolutely need to know this for exams. It comes from the Court of Appeal case of R.V. Twist in 2011.
Twist. Okay, the twist test. What does it involve?
It's a clear, three-stage process to determine if a statement falls foul of the hearsay rule under the CJA.
Identify the relevant matter you are seeking to prove. What specific fact is the party trying to establish using this communication?
Step 1, what are we trying to prove?
Step 2. Ask, is there actually a statement of that matter contained in the communication? Is the specific fact you identified in Step 1 actually stated, either explicitly or implicitly? If the answer is no, it can't be hearsay on that point.
Step 2, does the communication contain a statement of that fact?
Step 3. If the answer to Step 2 is yes, then apply the S11153 purpose test. Was it a purpose, or none of the purposes, of the maker of the communication that the recipient, or indeed any other person, should believe that matter or act upon that matter as being true?
Step 3, was belief or action the maker's purpose regarding that specific matter?
If the answer to Step 3 is yes, then it is hearsay under the CJA. If the answer is no, if that wasn't the maker's purpose, then it is not hearsay under the CJA definition.
Okay, that seems logical. Identify the fact, see if it's stated, then check the maker's purpose regarding that fact.
And Twist also added a crucial reminder. Even if a statement gets past this test and is classified as not hearsay,
It still has to be relevant.
exactly, it must still be logically probative of an issue in the case to be admissible. Don't forget relevance.
Let's try applying Twist to another case example. You mentioned Elliot from 2010.
Yes, Elliot. Letters were sent to the defendant referring to his gang membership. Prosecution wants to use these letters to prove he's a gang member.
Okay, Twist test. Step 1, matter to prove. Defendant is a gang member.
Step 2, statement of that matter in the communication. Yes, the letters contain references about his gang membership.
Step 3, maker's purpose. Was the purpose of the people writing the letters to cause the defendant, the recipient, to believe he was a gang member or to act on that belief?
Highly unlikely, isn't it? Their purpose was probably something else, internal gang communication, instructions, planning, whatever. It wasn't to convince the defendant of his own membership status.
So applying Twist, the answer to Step 3 is no.
Therefore, the letters were held not to be hearsay evidence of his gang membership under the CJA definition. Elliot 2010 is a good, clear illustration.
Okay, let's try the Activity 9.2 scenario. Alex charged with murdering his wife, Beatrice. Prosecution wants to prove there were bloodstains on the carpet. Evidence. Alex asked his neighbor, "Do you know how to get bloodstains out of a carpet?" Is this hearsay evidence that there were bloodstains?
Right, let's apply twist. Step 1. Matter to prove. There were bloodstains on the carpet.
Step 2. Statement of that matter in the communication. Well, the question refers to bloodstains. You could argue it implicitly asserts their existence. Let's assume yes for step 2.
Okay. Step 3. Maker's purpose. Was Alex's purpose in asking the neighbor that question to make the neighbor believe there were bloodstains, or to get the neighbor to act on that belief?
No, surely his purpose was just to get information. Cleaning advice.
Exactly. His purpose wasn't communication of the fact of stains, it was seeking information. So the answer to step 3 is no.
Meaning, under the CJA definition as applied by Twist, Alex's question is not hearsay evidence of the fact that there were bloodstains.
Correct. But is it admissible?
Yes, absolutely. As original evidence. The fact he asked that question is highly relevant, isn't it? It suggests knowledge, maybe consciousness of guilt.
Precisely. It's relevant to his state of mind, which is relevant to whether he committed the crime. So it comes in as original evidence, not hearsay evidence of the stains themselves. Remember that Activity 9.2 scenario.
Okay, I think I'm getting the hang of this definition stage. So under the CJA, hearsay, out-of-court statement plus use for truth of matter stated. Matter stated, defined by S.153, Maker's purpose test, belief or action. Applied via the 3-stage twist test. This reversed purely on implied assertions, but if it is hearsay according to this test, it's out. Unless
it can get through one of the statutory gateways for admission set out in Section 114.
Right, the exceptions. Section 114.1 lists the ways hearsay can be admitted in criminal proceedings. What are the main categories?
There are 4 principal gateways listed there.
First, admissibility by agreement. Section 114.1.3 thing. If both sides agree, it comes in. Simple enough.
Second, admissibility under other specific statutes. Section 114.1a. Various other laws make certain types of evidence, like business documents, sometimes admissible. We won't focus heavily on those today.
Okay, then the big ones for us.
Third, admissibility under preserved common law rules. That's Section 114.1, which points us to Section 118. This keeps some of the old established exceptions alive, most importantly res geste.
And fourth.
Fourth, admissibility where it's considered to be in the interests of justice. Section 114.1d. This is the broad, flexible safety valve provision.
So for exams, we really need to focus on unavailability under S.116, the interest of justice under S.11141D, and the preserved common law rules in S.11at, especially res geste.
Exactly. And as the case of Riet noted in 2012, the application of S11162, especially the fear ground, and S1111D tend to be the most litigated and controversial areas.
We also need to remember those supplementary provisions, sections 121, 123, 126, providing safeguards. We'll come back to those.
Let's start with a major gateway then. Section 116, the unavailability exception. This deals with situations where the original maker of the statement simply cannot give oral evidence for specific, recognized reasons.
Okay, makes sense. The person who said it isn't available to testify. How does S.11 allow their statement in?
Well, under S111 Sis 1, a statement not made in oral evidence, so typically a written statement or perhaps a recording can be admitted if 3 key conditions are met.
3 conditions. What are they?
Condition A. Oral evidence by the maker would have been admissible of that matter. Basically, if the person were in court, could they have lawfully testified about this? This generally limits S1116 to first-hand hearsay, although multiple hearsay isn't absolutely excluded if other rules apply.
Okay, first-hand hearsay usually. Condition B.
The maker of the statement, the relevant person, must be identified to the court's satisfaction. You need to know who actually made the statement. The case of Mayers confirmed this.
Right. Can't be an anonymous statement under S116. And condition C.
One of the 5 specific conditions listed in Section 116, subsection 2, explaining why the maker is unavailable, must be satisfied.
Okay, the 5 reasons for unavailability in S1162. Let's go through them.
First, S.160a. The person is dead. Seems straightforward.
But you mentioned earlier that this is where human rights concerns bite hardest.
Absolutely, because the witness is permanently unavailable for cross-examination. Following the important cases of Horncastle in 2009 and Evans in 2010, the rule now is that a statement by a deceased witness is only admissible under this gateway if it can be shown to be demonstrably reliable, or if its reliability can somehow be properly tested and assessed by the jury.
So just being dead isn't enough if admitting the untested statement would make the trial unfair.
Precisely. Fairness, reliability, testability are key.
And the case of Ibrahim from 2012 really drove this home, didn't it?
It did. Ibrahim involved a rape conviction that relied heavily on the statement of the complainant, who had unfortunately died before the trial. Her statement was untested, largely unsupported by other evidence.
So it met the technical criteria of S.11c on 1 and 2, identified maker, dead, oral evidence would have been admissible.
Yes, technically admissible under S11CN, but the Court of Appeal said the judge should have excluded it anyway, using the power under Section 78 of PACE 1984, the Police and Criminal Evidence Act.
Why exclude it under PACE .78?
Because the statement was central to the case, its reliability hadn't been demonstrated or tested, and admitting it in those circumstances would have had such an adverse effect on the fairness of the proceedings that it ought not to have been admitted. That's the S.78 test.
So Ibrahim shows that even if you tick the boxes in S.16, fairness considerations, often informed by ECHR principles and assessed using tools like PACE's Eliminate 7.8, can still lead to exclusion. The court in Ibrahim even looked at the S.114 and 2 factors the checklist for the Interests of Justice Gateway to help inform its S.78 decision. Remember Ibrahim 2012.
Okay, so A is dead, but with reliability caveats. What's B?
Section 116(2)(b). The person is unfit to be a witness because of their bodily or mental condition. The case Leverage from 2007 is given as an example where this applied.
Okay, unfit.
Section 116(2)(c). The person is outside the United Kingdom, and it is not reasonably practicable to secure their attendance.
Reasonably practicable, what does that involve?
It means the court has to weigh things up. How important is the evidence? How much would it cost to get them back? How inconvenient would it be? Are there specific reasons making it genuinely difficult? Maybe they're ill, or in a country with no extradition treaty. The case Guillema from 2007 outlines these factors.
And you'd also have to consider if technology could help, right? Like a live video link.
Yes. The possibility of a live link is relevant, as mentioned in Radak back in 1999. And importantly, Bailey from 2008 confirmed that just because a witness deliberately went abroad doesn't automatically make their statement admissible under this heading. The court still needs to be satisfied it's not reasonably practicable to get them back or hear from them remotely. Remember Guillema, Radak, and Bailey.
Okay. Outside UK and not reasonably practical to attend?
Section 116(2)(d). The person cannot be found, even though reasonably practicable steps have been taken to find them.
So the police or relevant party has to show they've made a proper effort.
Yes. In Adams from 2007, admission was refused precisely because the court felt reasonable steps had not been taken to locate the witness.
NTD in 2009 emphasized the importance of the right to confrontation here. The court needs to see proper evidence of the steps taken. Cost is a factor, but you can't just give up easily if the evidence is important. Remember Adams and TD.
Okay, cannot be found despite reasonable steps.
That leaves them. Section 116. 2E. This is the fear ground. The person does not give evidence through fear, and the court gives leave for their statement to be admitted after considering specific factors listed in S.11
Fear. How is that defined?
It's defined broadly in S.11 It includes fear of death or injury, or even fear of financial loss, either to the witness themselves or to another person, or damage to property.
And it's about the witness's subjective state of mind.
Yes, the test is whether the witness is genuinely in fear. Cases like Nelson 2009 and Doherty 2006 confirm this. And critically, the case Horncastle clarified that the fear doesn't have to be caused by the defendant or their associates.
Really, so it could just be a general climate of fear in the area or fear based on the defendant's reputation.
Exactly. However, if the fear is attributable to the accused or people acting for them, that becomes a very strong additional factor in favor of admitting the statement. It prevents defendants from benefiting by intimidating witnesses into silence.
But judges need to be careful here. Can't just take someone's word for it.
No, courts are warned against too readily accepting assertions of fear. They should scrutinize the claim and also consider whether using special measures like screens in court or giving evidence remotely might enable the witness to testify despite their fear. Those should generally be tried first.
Any key cases summarizing the principles on fear?
Shabir from 2012 provides a useful summary, drawing on the key cases like Horncastle, Ibrahim, and Riyad. Remember Horncastle, Nelson, Doherty, and Shabir for the fear ground.
Okay, that covers the 5 grounds in S.1164. Is there anything else critical about S.116?
Yes, one very important point. Section 116, subsection 5, this acts as a kind of integrity clause.
What does it do?
It prevents the admission of hearsay under S1116 if the unavailability of the witness was caused by the person seeking to admit the statement or by someone acting on their behalf in order to prevent the witness from giving evidence.
So if you deliberately get rid of a witness, you can't then use their statement.
Essentially, yes. The case Rowley from 2012 held that being an effective cause of the unavailability is enough to trigger this section. You don't necessarily have to be the sole cause. It stops manipulation of the rules. Remember Rowley 2012?
Right, that makes sense. Let's try applying S.1 and Son to those Activity 9.3 scenarios. Dave charged with murdering Edgar in a pub.
Okay. Scenario A. Fiona, a barmaid, heard an unknown customer say Dave acted in self-defense. Fiona told Dave's brother, who told Dave. Defense wants Fiona to testify about what the customer said. Assume Fiona is now unavailable. Can the customer's statement come in via S.11 scene?
Who made the original statement? The unknown customer. Where does it go? Customer, Don Fiona, my brother, Dave Court. That's multiple hearsay, isn't it?
It is. Section 116 is primarily designed for first-hand hearsay, statement made by the unavailable person themselves. While not an absolute bar to multiple hearsay if other conditions are met, you'd certainly need to consider Section 121, which deals specifically with multiple hearsay, in addition to S.1116.
And there's another problem here, surely. The original maker, the customer, is unknown.
Exactly. That fails condition S.1161b. The maker isn't identified, so S.116 alone is definitely not sufficient here.
Okay. Scenario B. Gerald saw Edgar attack Dave first. He gave a statement saying this. Now he refuses to testify because he's afraid his wife will leave him if she finds out he was in the pub. She disapproves. Dave's brother wants to testify about what Gerald told him. Can Gerald's statement come in under S.111c?
The potential ground here is S.11c. Gerald says he fears his wife leaving him. Does that count as fear of financial loss under S.11c?
It seems a stretch, doesn't it? Is that really the kind of fear Parliament had in mind? It feels more like fear of personal consequences or embarrassment.
I agree, it's arguable, but courts would likely see this as simple unwillingness or reluctance, rather than the kind of qualifying fear envisaged by the Act, death, injury, significant financial detriment. So S.11c probably doesn't apply to Gerald.
Right. Scenario C. Harry saw the incident, gave a written statement saying Edgar attacked Dave first. Harry has now gone abroad and can't be traced. Defense wants to admit his statement under S.11c. But there's a rumor Dave paid Harry to leave because the statement was actually false and Harry wanted to avoid being cross-examined.
Okay, potential ground is S.1172c, outside UK, and not reasonably practicable to secure attendance. If Harry genuinely can't be traced abroad, that condition might be met.
BUT, the rumor about Dave paying him off.
That triggers Section 116.5, the integrity clause. If the prosecution can prove, on the balance of probabilities, that Dave caused Harry's unavailability by paying him to leave because the statement was false, then Harry's statement becomes inadmissible under S.1165, even if the conditions in S.1162c are technically met.
So S.1165 overrides the unavailability ground if the party relying on the statement caused the unavailability improperly.
Exactly. It shows how the different parts of the section interact. These scenarios really help illustrate the need to apply the specific conditions very carefully.
Okay, so S.1110 covers unavailability for specific reasons. Dead, unfit, abroad, lost, fear. But crucially subject to reliability and ECHR fairness considerations, especially for death fear, and the anti-manipulation rule in S.11 System 5. What about the old common law exceptions the CJA kept?
Right. Section 118 preserves a limited number of common law hearsay rules for criminal proceedings. Most of the old common law hearsay jungle was cleared away by the CJA, but a few specific rules were deemed useful enough or sufficiently well established to keep.
Are there many?
There are some relatively minor ones, listed things like published works on public matters, certain public documents and records, evidence of age or date of birth from specific sources, and evidence of reputation for things like character or family history pedigree. Their scope is quite limited in practice.
What else did S.18 preserve?
It also preserves rules relating to expert evidence and, importantly for other parts of evidence law, the common law rule that a confession made by an accused person is admissible as evidence against its maker, subject to rules about oppression and reliability under Pacey.
But you said there were two major preserved exceptions we need to focus on.
Yes. The two big ones preserved by S.119 that you're likely to encounter are, first, statements made in furtherance of a common enterprise relevant in conspiracy cases, and second, and most importantly for general application, res gestae.
Res gestae. Latin phrase means things done or things that happened, right?
Exactly. In the context of hearsay, it refers to statements that are considered so closely connected with an event, temporally and contextually, that they're seen as part of the event or transaction itself, rather than just a later narration about it.
And the key idea is,
The key idea is that the statement was made in circumstances where the possibility of the maker concocting a story or distorting their account is effectively excluded. They're speaking spontaneously as part of the unfolding event.
so this often covers things like spontaneous comments made under the stress or excitement of witnessing something dramatic.
Precisely. The classic example is the excited utterance. And the key case setting out the test for admitting these excited utterances as part of the res gestae is R.V. Andrews from 1987.
Andrews, what did it establish?
Andrews laid down the criteria, often called the Ackner criteria, after Lord Ackner, who gave the judgment. The focus is on whether the statement was made in conditions of such spontaneity or involvement in the event that the risk of fabrication or distortion is negligible. Factors include how closely linked in time and place the statement was to the event, whether the maker's mind was still dominated by the event, and whether there was any real opportunity for concoction.
So it's about the link between the statement and the event being so strong that the statement is inherently reliable because there was no time or opportunity to make it up.
That's the core principle. The case Spence from 2011 applied these Andrews criteria. The materials quote a key passage from Spence, 711, emphasizing the utterance must be so immediate, so instinctive that the jury was entitled to reject any possibility of concoction or distortion. Remember Andrews 1987 and Spence 2011 for res gestae.
Got it. Spontaneity, contemporaneity, lack of opportunity for concoction, the Andrews test for excited utterances under the res gestae exception, preserved by S.118.
If a statement meets those criteria, it can be admitted under this gateway.
Okay, so we have S.116 for unavailable witnesses, S.111C preserving res gestae, and a few others. What about that flexible catch-all, the interests of justice gateway?
Ah, yes, Section 114, subsection 1, paragraph DS121D. This is the broad discretionary gateway. It allows hearsay evidence to be admitted if the court is satisfied that, despite it being hearsay, its admission is in the interests of justice.
The safety valve.
Yeah.
But how does the court decide what's in the interests of justice? It sounds very open-ended.
It is intentionally flexible, but it's not an entirely unfettered discretion. Parliament provided guidance. When considering admissibility under S.115, the court must have regard to a list of mandatory factors set out in Section 114, subsection 2, S.1.22.
Okay, a statutory checklist. What kind of factors are on this S.114 list?
It's quite comprehensive. The list aims to help the court assess the overall reliability and fairness of admitting the hearsay. It includes things like the probative value of the statement, how important or helpful is it to resolving an issue in the case, what other evidence is available on the same matter, how important is the statement to understanding the case as a whole, the circumstances in which the statement was made, was the maker under pressure, were they identified, how reliable does the maker of the statement appear to be, how reliable does the evidence of the statement being made appear to be, is oral evidence available, if not, why not? How much difficulty will the opposing party face in challenging the statement, and the extent to which that difficulty is likely to prejudice the opposing party?
Wow, that's quite a list. It really forces the court to think about the reliability issue from different angles.
It does. The court has to consider all these factors, plus any other factors it thinks are relevant in the specific circumstances of the case.
And this gateway, S1111D, can it be used by both prosecution and defense?
Yes, it's available to both sides. And unlike S116, which is mainly for first-hand hearsay, S114D can potentially be used to admit multiple hearsay, although remember Section 121 imposes additional hurdles for multiple hearsay generally.
Has this gateway been used in practice?
Yes. For instance, the case JS from 2009 used this gateway to admit a child's statement in circumstances somewhat similar to the old Sparks case. It illustrates how S.1141D can potentially allow in evidence, particularly perhaps for the defense, that might have been excluded under the rigid old common law.
But there's a really important warning about using S.114D, isn't there?
Yeah.
Regarding its relationship with S.116.
Yes, absolutely critical point. The courts have repeatedly warned that S.11D should not be used as a backdoor to get evidence in when it fails to meet the specific requirements of S.117, particularly where the reason it fails S.116 is simply that the witness is available but unwilling to testify.
Why is that?
Because Parliament deliberately drafted the specific, detailed conditions for unavailability in S.116, if a witness doesn't meet those conditions, for example, they aren't dead, unfit, abroad, lost, or genuinely in fear, then allowing their statement in via the general interests of justice gateway would undermine the specific structure Parliament created.
Was this just judicial opinion, or is there a key case?
It was mentioned obiter in passing in O'Hare in 2006, but the decisive case is RVZ in 2009. You must know Z.
EZ 2009, what happened?
In Z, the prosecution wanted to introduce hearsay evidence about the defendant's previous bad character. The evidence came from a witness who was perfectly available to testify, but she simply refused because she wanted to move on with her life. She didn't meet any of the S.16 unavailability grounds.
So the prosecution tried to use S.1161D instead.
Exactly. And the trial judge allowed it under the interests of justice,
Right.
but the Court of Appeal quashed the conviction. They stressed that S.1141D must be applied cautiously, particularly where S.114 is the relevant section dealing with unavailable witnesses, but its conditions aren't met. They said using S.1141D just because a witness was unwilling but available would bypass the carefully drawn limits of S.11C.
So Z firmly establishes that S.1141D isn't a loophole for getting around S.11 some conditions if the witness is available but just doesn't want to cooperate. Remember Z 2009.
They contrasted Z with cases like Isike and Exibri, where S.111D was correctly used, but in those cases, the statements were seen as integral parts of the incident being tried, making them more akin to res geste, perhaps, and highly relevant to context.
And ED from 2010 was another case where using S.141D was criticized.
Yes, partly because the prosecution was seen as being at fault for the witness not attending, again emphasizing that the circumstances surrounding the unavailability or non-attendance matter when considering the interests of justice.
Okay. Now let's revisit that tricky point about confessions. We said S.118 preserves the rule that a confession is admissible against its maker. What about using hearsay within a confession against a co-defendant? You mentioned the case Y 2008.
Yes, Y 2008. The question was, could the prosecution use S.111D, the interests of justice gateway, to admit parts of Defendant 1's confession that implicated Defendant 2, even though the common law rule, preserved by S.118, says confessions are only admissible against the maker?
It seems like S.118 should block that, shouldn't it?
That was the argument made by the defense, but the Court of Appeal in Y 2008 took a different view. They reasoned that Section 114.1 effectively replaces the common law rules on admissibility except where specifically preserved, and Section 118, they said, only preserves common law rules relating to admissibility, not rules of inadmissibility.
That's quite technical.
It is. Their conclusion was that since S.1141D is a new statutory gateway for admissibility created by the CJA, it can, in principle, override the old common law limitation. So legally, it is possible to admit hearsay within a confession against a co-defendant via S.1141D.
Wow. So legally possible, but does it actually happen? Using one defendant's out-of-court, untested statement against another sounds highly problematic from a fairness perspective.
It absolutely is. And this brings us to the crucial caveat from Y 2008. While the Court of Appeal held it was legally possible, they stressed it should not be routine or done lightly.
Why not?
Because all the inherent dangers of hearsay are magnified in this situation. It's a co-defendant statement, likely made out of self-interest, untested by cross-examination by the person it implicates. The court must rigorously apply the S.114 Store and 2 factors, focusing intensely on reliability and the potential for prejudice.
So in practice, concerns about reliability and fairness will usually mean that such evidence is excluded.
That's the strong indication from Y. It would require very exceptional circumstances, perhaps strong independent corroboration, for such evidence to be admitted against a co-defendant under S.111T1D. The court did note, however, that it might be easier for a co-defendant to use such a statement if it helped their own defense, as that raises different fairness issues. Remember Y 2008 for this point.
Okay, so S11151D, the interests of justice safety valve, assessed using the mandatory S1114 reliability factors. Available to both sides can cover multiple hearsay, but UT, not a loophole for S.116Z. And while legally capable of admitting hearsay in a confession against a co-defendant, strong fairness and reliability concerns usually prevent this in practice. Why?
That's a good summary. Now, beyond the gateways themselves, we need to look at those supplementary provisions the safeguards Parliament included to try and ensure fairness when hearsay is admitted.
Right, because even if hearsay gets in through a gateway, it still hasn't been tested by cross-examination in the same way.
Precisely. The inherent weaknesses remain. So first, Section 121 deals specifically with multiple hearsay.
What does it do?
It imposes additional requirements for admitting multiple hearsay A, telling B what C said. Reflecting the increased risk of unreliability the further you get from the original source, S121 generally requires multiple hearsay to fit within specific gateways, like S1116, a corrupt 111E, or S1111D, and the court must be satisfied that the value of the evidence justifies its admission despite the difficulties in testing it.
Okay, extra hurdles for multiple hearsay. What else?
Section 124 is a very important safeguard related to credibility. It allows a party who is opposing admitted hearsay evidence to challenge the credibility of the original maker of the statement, even though that person isn't in court to be cross-examined.
How does that work? Can you bring evidence about the absent witness's previous lies or bad character?
Yes. Section 124 allows you to adduce evidence relevant to the absent maker's credibility that would normally only be admissible during cross-examination, like previous inconsistent statements or evidence of bias or dishonesty. It gives the party challenging the hearsay some tools to undermine the reliability of the statement, even without the maker being present.
That sounds useful.
It is. The Supreme Court in Horncastle actually praised S124 at paragraph 36, noting it can sometimes put the challenging party in a better position than if the witness were present, because normally on collateral issues, things only relevant to credibility, you're bound by the witness's answer in cross-examination. Here, you can bring independent evidence. Remember Horncastle on S124.
Okay, S124 for credibility challenges. What's next?
Section 125 provides a crucial judicial power to stop the trial, but it applies only in jury trials.
Stopping the trial. How does that work?
Under S125(1), if the prosecution's case against the defendant depends wholly or partly on admitted hearsay evidence, and the judge considers that the hearsay evidence is so unconvincing that, considering its importance to the case, a conviction based upon it would be unsafe. Then, the judge must either direct the jury to acquit the defendant, or, if they think a retrial might be fair, discharge the jury.
Wow, that's a significant power. A mandatory stop if the hearsay foundation is too shaky.
It's a major safety net against convictions resting on weak or unreliable hearsay, specifically designed for jury trials where the judge has concerns about how the jury might assess the hearsay.
Okay. Any other safeguards?
Yes. Section 126 deals with general discretions to exclude evidence, even if it's technically admissible under one of the hearsay gateways.
Does it preserve existing discretions?
Yes. S12600 explicitly preserves two key existing discretions. First, the common law discretion to exclude evidence if its prejudicial effect outweighs its probative value. And second, the absolutely vital discretion under Section 78 of PACE 1984, which we saw used in Ibrahim.
Remind us of the PASO S.78 test.
SFA 78 allows the court to refuse to allow evidence on which the prosecution proposes to rely if it appears to the court that, having regard to all the circumstances, including how the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it.
Okay, so those existing discretions are preserved. Does S.126 add anything new?
Yes. Sensi 1261 introduces a new statutory discretion specifically for hearsay. It allows the court to exclude an otherwise admissible hearsay statement if it's satisfied that the case for excluding it, taking account of the danger that admitting it would result in an undue waste of time, substantially outweighs the case for admitting it, considering the value of the evidence.
So another layer of judicial control, looking at things like time wasting versus the actual value of the hearsay.
Exactly. These supplementary provisions, S.121 on multiple hearsay, S.124 on credibility, S.125 on stopping the trial, and S.126 on general discretions, are all designed to work alongside the gateways to ensure that the relaxation of the hearsay rule doesn't compromise trial fairness.
And fairness brings us squarely to the human rights dimension.
Indeed. The Human Rights Act 1998 incorporates the European Convention on Human Rights into UK law. This means our courts must interpret legislation compatibly with the Convention rights where possible, and they must take account of judgments from the European Court of Human Rights, ECTHR, in Strasbourg, although those judgments aren't strictly binding in the same way as domestic precedent.
And the key convention right here is
Article 6, The right to a fair trial, and specifically within Article 6, Paragraph 3, Article 6, 3D, which guarantees the right of everyone charged with a criminal offense to examine or have examined witnesses against him.
The right to confrontation. Basically, the right to cross-examine the witnesses the prosecution calls against you.
That's the core of it. It's seen as a fundamental element of a fair trial, ensuring equality of arms and allowing the defense to test the evidence presented. Though the ECTHR always emphasizes that Article 6.3d is just one aspect of the overall right to a fair trial under Article 6.1.
How has the ECTHR approached hearsay evidence under Article 6.3?
Historically, the ECTHR maintained that the admissibility of evidence is primarily a matter for national law and national courts. Their role wasn't to dictate rules of evidence, but to assess the overall fairness of the trial. They also acknowledged the need to balance the defendant's rights with other legitimate interests, like witness protection or the effective administration of justice.
But then came the issue of convictions based heavily on hearsay.
Yes, this led to the development and subsequent refinement of the so-called sole or decisive rule. It's been a fascinating judicial dialogue.
Where did it start?
The ECTHR hinted in cases like Luca v. Italy back in 2003 that a conviction based solely or decisively on the evidence of a witness whom the accused hasn't been able to cross-examine, either at trial or during the investigation, might automatically violate Article 6.
How did UK courts react initially?
There was some resistance. For example, in Selleck in 2005, the Court of Appeal suggested there shouldn't be an absolute rule, especially if the defendant themselves had caused the witness's absence through intimidation. They emphasized balancing rights.
But the ECTHR seemed to firm up its position.
It did, most notably in the case of Al-Khawaja and Tari v. UK in 2009. The ECTHR took a strong stance stating that Article 6.3 rights were specific guarantees, not just aspects of overall fairness. They found violations of Article 6 where convictions had been based solely or decisively on statements from absent witnesses, one dead, one absent through fear, without sufficient counterbalancing factors to compensate for the lack of cross-examination.
So, sole or decisive untested hearsay, unfair trial. That sounds like a direct challenge to the CJA 2003 framework, which does allow such evidence in certain circumstances, like S11 Sen.
It certainly set up a direct confrontation, and the UK Supreme Court met that challenge head-on in the landmark case of R.V. Horncastle in 2009.
Horncastle.
Yeah.
A hugely important case. What did the Supreme Court decide?
In a powerful judgment delivered by Lord Phillips, the UK Supreme Court unanimously declined to follow the ECTHR's 2009 Al-Khawaja ruling on the sole or decisive rule.
They refused to follow Strasbourg. Why?
They gave several reasons. They argued the ECTHR hadn't provided a clear, reasoned principle for why sole or decisive evidence should automatically lead to unfairness. They felt such a rigid rule didn't fit with the nuanced, principle-based approach of the common law tradition. And crucially, they robustly defended the CJA 2003 framework itself.
How so?
They argued that the safeguards built into the CJA 2003, things like the strict conditions for admissibility under S116, the credibility challenges under S124, the power to stop the case under S125, the judicial discretions under S126, and PACE S.7 were sufficient in themselves to ensure a fair trial, even if the hearsay evidence was sole or decisive. They essentially told Strasbourg, our domestic safeguards are adequate. Remember Horncastle 2009?
Wow. That's a major moment of judicial dialogue or maybe disagreement between the UK's highest court and the European Human Rights Court. How was this resolved?
The final word came when the Al-Khawaja and Tari case went back to the ECTHR, this time before the Grand Chamber, the highest level of the court. And in their judgment in Al-Khawaja and Tari v. UK in 2011, the Grand Chamber effectively agreed with the UK Supreme Court.
Really? They changed their minds.
They refined their position significantly. The Grand Chamber held that the admission of sole or decisive hearsay evidence does not automatically result in a breach in Article 6. A conviction based on such evidence can be compatible with fairness requirements, provided that there are sufficient counterbalancing factors, including strong procedural safeguards, in place.
And those safeguards could include the ones in the CJA 2003.
Precisely. The Grand Chamber acknowledged the strength of the CJA safeguards discussed in Horncastle. This ruling essentially validated the UK's legislative framework, confirming that it is capable of ensuring fairness if applied robustly. This crucial Grand Chamber decision from 2011 resolved the conflict. Ormerod's commentary famously asked, worth the wait. Remember Al-Khawaja and Tari v. UK 2011? Horncastle v. UK in 2014 confirmed the dialogue was over.
So the bottom line is, Sole or decisive hearsay can be admitted, but only if the CJA safeguards are properly and rigorously applied to ensure overall trial fairness.
That's the current position. It places a heavy responsibility on trial judges to actively use the safeguards.
And we saw this reflected back in cases like Evans.
Yes, Evans in 2010 decided after Horncastle but before the Grand Chamber ruling already confirmed that even for deceased witnesses under S1-2, the court needed to be satisfied about reliability or testability, anticipating the need for counterbalancing factors.
Okay, given this need for robust application, is there a practical framework courts use?
Yes, the Court of Appeal in RV Riot in 2012 set out a very helpful practical framework, almost a checklist, for courts to follow when considering admitting hearsay evidence, particularly potentially decisive hearsay, in light of the ECHR principles established by Horncastle and Al-Khawasha Grand Chamber.
The RIAT framework, what are the steps? You mentioned 6.
Yes, it's a structured approach. 1. First, does the hearsay fall within one of the specific statutory gateways? If not, it's generally inadmissible unless S11141D applies. 2. Second, is there material available that allows the reliability of the hearsay to be tested and assessed, relevant to S.124 credibility challenges? 3. Third, does the specific gateway being considered have its own built-in interests of justice test at the admissibility stage, like the S1112 factors for the safety valve? 4. Fourth, if no other gateway applies, should the evidence be considered for admission under the general interests of justice gateway, S1114D, applying the S1112 factors? 5. Fifth, even if technically admissible, should the evidence be excluded using the general discretions under PACE S78 or CJA S.126, considering fairness, prejudice, time waste? Sixth, in a jury trial, if the evidence is admitted but later appears unconvincing, should the judge stop the case under S125 because a conviction would be unsafe?
That seems a thorough process.
It is, and Riet stressed that the importance of the hearsay evidence, including whether it's sole or decisive, is a crucial factor running through all these stages of decision-making, even if it's not an absolute bar to admission anymore. Remember Riet 2012?
Did later cases refine this? You mentioned Taylor.
Yes, Taylor in 2013 followed Riet and clarified the testability principle. It said the hearsay doesn't need to be demonstrably reliable before being admitted, but there must be sufficient tools available for the jury to assess its reliability properly. Factors like the maker having no apparent motive to lie or the hearsay fitting neatly with other independent evidence can help show it's accessible. Remember Taylor 2013.
And what about the reason for the witness's absence? Does that still matter after Al-Khawasha Grand Chamber?
It does. The ECTHR case Price v. UK from 2016 confirmed that the reason for absence is important. If there isn't a good reason, like death or genuine fear, that weighs against admission. The trial court needs good reasons for not securing attendance. However, Price also reiterated that even without a good reason for absence, sufficient independent supporting evidence and the robust application of domestic safeguards, like the CJA ones, can still prevent an Article 6 breach. Remember Price v. UK 2016.
So to summarize the ECHR impact, we went from Lucas suggesting a sole decisive rule through the tension between Al-Khawasha 2009 and Horncastle to the resolution in Al-Khawasha Grand Chamber 2011. The final position, hearsay can be sole or decisive. IDAF sufficient counterbalancing safeguards are robustly applied. The RIAT framework provides the practical steps for courts to navigate this, ensuring Article 6 compatibility.
That's a very good summary of a complex journey.
Okay, nearly there. Before we move to critical evaluation, just a quick loop back to relevance. Foundational principle always applies.
Always. Evidence has to be relevant to be admissible, whether it's hearsay or not.
And you said determining the purpose for reducing a statement, which is key for the twist hearsay test, also links to what issue the statement is relevant to.
Exactly. Let's think about Carolee again. Those phone calls asking for drugs. Under the CJA and twist, they aren't hearsay as evidence that Carolee was a dealer because that wasn't the caller's purpose.
Right.
But the question remains, even if they aren't hearsay for that purpose, are they relevant circumstantial evidence to prove he was dealing?
Well, you'd think so, wouldn't you? Lots of people calling asking for drugs seems pretty relevant.
It does seem relevant. It highlights that classifying something as not hearsay under the CJA definition doesn't automatically answer the separate question of its relevance and probative value for the issue the party wants to prove. It's something commentators like Ormerod have discussed. Was the common law perhaps too narrow even on relevance in Carolee? It's worth pondering.
It definitely is. Which leads us nicely into critical evaluation. The CJA 2003 aimed to reform hearsay, make it more logical, more flexible, but has it succeeded? Are there still debates?
Oh, absolutely. The reform wasn't the end of the story. The materials highlight three main areas for critical evaluation.
The definition of hearsay itself
Yeah.
is the CJA definition in S.11 Vine 3, especially how it excludes implied assertions via the maker's purpose test, applied through twist, actually satisfactory. Is it clear enough in practice?
We saw cases like Leonard had difficulties, and the fact the Court of Appeal needed to lay down the detailed twist test suggests it wasn't immediately obvious. Does any ambiguity matter?
Hugely. Getting the initial classification wrong, deciding if something is or is not hearsay under the Act, has fundamental consequences for admissibility. If it's not hearsay, it's potentially admissible subject only to relevance and discretion. If it is hearsay, it needs a gateway. Clarity in the definition is vital for consistency and fairness.
Okay, definition clarity is one area. What's second?
Second, sufficiency of the safeguards. We've talked about the various provisions, S121, multiple hearsay, S124, credibility, S125, stopping trial, S126 shows 0.78, patey discretions, the S14, sum so 3 factors. Do these mechanisms adequately address the inherent risks of admitting hearsay, the lack of cross-examination, potential unreliability, risk of mistake or concoction?
Are they effective in practice? Do judges always apply them robustly?
That's the critical question. The framework looks good on paper, but are the safeguards always strong enough in reality to protect the defendant from potentially unsafe convictions based on untested evidence?
And the third area ties into the safeguards, presumably.
Third, fair trial and confrontation in practice, ECHR. We know the Al-Khawaja Grand Chamber said the CJA framework is compatible with Article 6.3d if the safeguards are applied robustly. So the critical question becomes, are they being applied robustly enough in practice?
Does the potential to admit sole or decisive hearsay, even with safeguards, truly sit comfortably with the fundamental right to confront your accuser?
That's the ongoing debate. Are the courts consistently applying the RIAT framework rigorously? Are they always properly grappling with the S1, 4, and 2 factors, or the need for testability from Taylor? Or are there cases, maybe like Z or Ibrahim, that raise questions about whether the balance is always struck correctly?
So it's about evaluating the law, not just as written, but how it operates on the ground. Does the complexity risk justice becoming too dependent on judicial navigation rather than clear principle?
That's certainly a valid point for critical analysis. Has the reform truly achieved the intended balance between admitting relevant evidence and ensuring fundamental trial fairness?
Okay. To help bring all this together, especially for anyone preparing for exams, let's briefly consider how we'd apply this law to those sample questions.
Good idea. Sample question 1. Albert is found with cocaine and cash. His phone has texts like, "Can I have thrice?" and "Hi, new customer, need cocaine." Prosecution wants to use the text. Albert says the cash was a gift from his Uncle Chen in China, who provided a statement confirming this before emigrating.
Okay, first the text messages. Prosecution wants to use them to prove Albert was dealing drugs. Are they hearsay? Apply twist.
1. Matter to prove. Albert was dealing drugs. 2. Statement. Texts implicitly assert he supplies drugs. 3. Maker's purpose. What was the texter's purpose? Likely to cause Albert to believe they wanted drugs and to act on that belief by supplying them.
So that seems to fit both S.1153A and B. Purpose was belief and action.
Which means, under twist, the text messages are hearsay evidence that he was dealing.
Okay, they're hearsay. Are they admissible? Is there a gateway?
S116 doesn't apply. Texters are unavailable in the specified ways. S118 doesn't apply. Res geste. Unlikely. So the prosecution will likely try S1114D, the interest of justice.
And the court would have to consider the S.1142 factors.
Absolutely. Probative value. High for the prosecution. Reliability. Very questionable anonymous texters. Circumstances unknown can't be challenged. Importance. High. Difficulty challenging. Maximum. The court would have a difficult balancing act, weighing probative value against the serious reliability issues and prejudice.
What about Uncle Chen's statement about the cash? Albert wants to use it.
It's an out-of-court statement used to prove the truth of the matter stated that he gave Albert the money. So it's hearsay. Gateway for the defense.
Uncle Chen is unavailable. He's emigrated to China, so S.11 same.
Looks promising. Let's check the S.11 scene conditions. 1A, oral evidence admissible. Yes, if he were here, he could testify he gave the money. 1B, maker identified. Yes, Uncle Chen. 1C, unavailability condition met. Yes, S.1116 2C outside UK. Is it reasonably practical to secure his attendance from China? Probably not, especially if he's emigrated.
So potentially admissible under S.1162C?
Yes, likely admissible, but safeguards apply. The prosecution could challenge Uncle Chen's credibility under S.124, free G evidence he has convictions for dishonesty or owes Albert money. And the judge retains discretion under List 126.78 PCI, though less likely to exclude defense evidence unless clearly unreliable or peripheral. If the prosecution case relied heavily on disputing this money origin, and Chen's statement was the only defense evidence but seemed shaky, maybe S125 could even be relevant if rejecting it would lead to an unsafe conviction, though S125 usually bites on prosecution hearsay.
Okay, that shows the process. Identify hearsay, twist, find gateway, S126 chills, 11413 on 8, consider mandatory factors, S142, apply safeguards, S124S, 126 chills, 78 PC it.
Exactly. Now, sample question 2 was an essay. Critically evaluate whether the CJA 2003 safeguards ensure prosecution hearsay doesn't render trials unfair, particularly in light of Al-Khawaja Grand Chamber.
How would you structure that?
Start by outlining the problem, the dangers of untested prosecution hearsay, and the importance of the Article 6.3d, right to confrontation. Then explain the CJA 2003 framework, the general rule, the gateways allowing hearsay in, especially S.1116 and S.1151d for prosecution, and then detail the specific safeguards intended to ensure fairness, SS 121, 124, 125, 126, S.78BC, the S.112 for factors.
Then bring in Al-Khawaja Grand Chamber.
Yes. Explain the ruling. The framework is compatible, provided the safeguards are robustly applied, even for sole or decisive evidence. This sets up your critical evaluation.
The critically evaluate part means discussing how robustly they have been applied in practice.
Precisely. Use case law. Discuss Ibrahim, where S.78 was needed despite S.116 being met. Z, misuse of S.1141D, perhaps ED, prosecution fault. Consider Price v. UK, relevance of reason for absence. Discuss whether courts always seem to sufficiently grapple with the S.1142 factors or the Riat-Taylor principles of testability accessibility.
So, conclude with a nuanced assessment. The framework is theoretically sound and ECHR compliant on paper, but its practical effectiveness and fairness depend entirely on consistent, rigorous judicial application of the safeguards, which remains a key challenge.
Exactly. That shows critical engagement with the law in practice.
Okay. We have covered a lot of ground, from the old rigid common law through the major CJA 2003 reforms, getting to grips with the twist definition, exploring the gateway's unavailability, res gestae, interests of justice, understanding the safety valve function, and dissecting the vital safeguards in the crucial human rights dimension, culminating in Al-Khawaja Grand Chamber and the Riot Framework.
It really is a dense and highly interconnected area of evidence law. Getting comfortable with those definitions, the specific conditions for each gateway, the purpose and function of each safeguard, and how the human rights principles overlay everything that's the key. Go back over the statutory provisions and definitely revisit the key cases we've mentioned. Subramaniam, Twist, Curley, Andrews, ZY, Ibrahim, Horncastle, Al-Khawaja, Riat, Taylor, Price. They bring the principles to life.
Practice applying that twist test systematically. Then, when you identify hearsay, walk through the potential gateways. If one applies, think about the safeguards. Use the RIAT checklist, perhaps, always keeping PACE S.78 and overall ECHR fairness in mind.
We genuinely hope this deep dive has helped demystify the rule against hearsay a bit and giving you a solid structure for understanding it.
Yeah.
To everyone preparing for assessments, truly the very best of luck.
Absolutely. This deep dive was brought to you by Sinorbit Academy, Sri Lanka, and it was based on the excellent educational materials made available by the University of London, for which we are very grateful. Thank you for joining us for this, well, complex but absolutely essential deep dive into criminal evidence.
And maybe one final thought for you to ponder as you continue your studies, building on that critical evaluation. While the law has evolved significantly to try and balance fairness with the need for relevant evidence, and the framework allows for sole or decisive hearsay if safeguards are robustly applied, does relying on potentially crucial but ultimately untested evidence ever sit entirely comfortably with the fundamental principle of being able to confront your accuser directly? It's a tension the law continues to manage day in, day out in courtrooms across the country.
Definitely something to think about. Until the next deep dive.